lot of people think that there's just treating patients. And one of the things I've seen in my career is that a degree in medicine opens up many, many doors and opportunities. And this is just one interesting offshoot of being a physician.
How did the transition to being an expert witness happen? Like while studying or during the practice, were you aware that doctors also do expert witness work, or was it a surprise when an attorney came knocking?
Yeah, it happened sort of serendipitously. I was at work, again, about a decade ago. One of my colleagues seemed busy and maybe slightly stressed at the end of the day, and I asked him what was going on, and he said he had a case that he had to prepare for and he didn't have time for it. And I said, oh, where's the patient? I can help them. And he said, no, this is a legal case. And then he said, wait a second, how long have you been out of residency? I think you can do it. And I'm like, I have no clue what you're talking about. And he said, are you free tomorrow? Can we go out to lunch? And so over that lunch, I got a crash course into this new space.
Welcome to another episode of On the Stand with Ashish Arun. Today, we are thrilled to welcome a truly remarkable guest to the show, Dr. J. Jordan Romano. From his Ivy League beginnings to becoming a trusted figure in the courtroom, Dr. Romano's career is nothing short of inspiring. Dr. Romano, welcome to the show.
Thanks for having me.
So let's start right from the beginning, as we usually do on our podcast, and ask you, why medicine? Did you always wanted to be a doctor, or it was destiny that brought you here?
The undergrad that I went to, the undergraduate school that I went to, minted a lot of doctors and lawyers. So it was sort of ingrained there that was a place that a lot of people went to. I'm not one of those individuals that knew from a young age that I was going to be a physician. It was something that it was more of a challenge. And based on my skill set, it was recommended as I was getting later in my years in my undergraduate that I should pursue it.
And how did the transition to being an expert witness happen? Like while studying or during the practice, were you aware that doctors also do expert witness work, or was it a surprise when an attorney came knocking?
Yeah, it happened sort of serendipitously. I was at work, again, about a decade ago. One of my colleagues seemed busy and maybe slightly stressed at the end of the day, and I asked him what was going on, and he said he had a case that he had to prepare for and he didn't have time for it. And I said, oh, where's the patient? I can help them. And he said, no, this is a legal case. And then he said, wait a second, how long have you been out of residency? I think you can do it. And I'm like, I have no clue what you're talking about. And he said, are you free tomorrow? Can we go out to lunch? And so over that lunch, I got a crash course into this new space. And I think that that's what's exciting about pretty much any field, but certainly in medicine, is that a lot of people think that there's just treating patients. And one of the things I've seen in my career is that a degree in medicine opens up many doors and opportunities. And this is just one interesting offshoot of being a physician.
And was this case, was it like a record review first, or did you end up testifying as well?
Was just initially reviewing medical records. There might have been a deposition in it that happened 4+ years later, which is rare, but it can happen. And that's what's interesting about the nature of these cases. It can start with simple record review, and the vast majority of them settle, but some do move on to trial, and it is over a longer time frame.
Mm-hmm. So do you have like a specific memory during deposition or during cross-examination where you're like, this is something that is really interesting and really exciting, and I really want to do this?
I think it was a combination of things. I don't remember like an epiphany moment. And I think that's what's kind of interesting. Most people are like, how did you know you were going to be good at it? I wasn't. I didn't. I thought I was helping a colleague, and I did one case, and I said, oh, that's interesting. You know, I'm wondering what it would look like to get more cases. And over the first couple of years, it was a slow start. And I think when I really started to lean into it was when the feedback came back from attorneys. And what's exciting too is when you get that first unexpected referral where your phone rings and you're like, how did you find me? And they said, oh, a friend of mine said you were doing this and that I should give you a call. And that was just a moment where you kind of sit back and you're like, oh, wow, that's kind of interesting. Somebody sought me out. And so I would say but that happened slowly. The vast majority of the work that I've done in the space obviously is in the latter years of those 10 years, the first year I did one case, right? The second year, maybe there were 2 or 3. And so it takes time in this space to get known and also be trusted. This is a situation where insurance companies are entrusting you with reviewing a case and sharing your opinions in defense of the care that not colleagues, but that physicians provided, or attorneys trusting for you to help share the story of the care that should have been provided and wasn't, or was provided but fell below the standard of care for their client who was harmed by that care or lack of care. So it is a very important role. And because of that reason, it's kind of a catch-22.
Yeah.
When you start out, to get better, you need to get more cases, but to get more cases, you have to be good at what you're doing. And so it's kind of the start is always a weird feeling. And so I enjoy sharing my story and helping others with that odd start and that catch-22, if you will.
Let me ask you about this conundrum that a lot of doctors have when, when you talk to them about being an expert witness. And I'm sure you've seen this in your training, the training work that you do. Doctors feel that they may be betraying their colleagues or the medical fraternity when they are testifying against another doctor or another hospital, another service provider. And on the other hand, there's this whole school of thought that bad medicine needs to be called out. So what's your take on that? That our doctors, what's the right thing to do as an expert witness? And should doctors be worried about betraying their fraternity when they are testifying or helping a plaintiff's attorney determine that the standard of care was breached in a medical malpractice case?
I've had that conversation a lot with physicians thinking about entering the medical malpractice space. And what I will tell you is once those individuals, it tends to be a view of those individuals who have not entered into the medical expert witness space. But once they actually see things from the other side, they see how important the role is. In the medical expert witness space, in medical malpractice, there's the standard of care. What any reasonable doctor would do in same or similar circumstances with same or similar training. And that's our standard as physicians, as clinicians, to uphold that standard. And this legal process requires experts to explain what that standard is and was it applied or was it not. And it's essential to have clinicians in this space. And that's where I see my role is. I want to invite more physicians and providers into this space and make sure that they have the skills to operate in this space so that everybody benefits. I think I don't blame individuals for seeing it. I wouldn't say I necessarily saw it that way. I just didn't understand the space. Maybe I knew it existed, but for the longest time, you're just busy going about your day to day. And then you hear something about, oh, do you want to testify in a malpractice suit? And most people's initial reaction is, why would I want to do that? And as you alluded to in an earlier question, the vast majority of the work actually isn't testifying. The vast majority of the work is reviewing records and discussing the care with the attorneys involved in the case. A very small percentage of the work will actually go to trial, depending on the specialty, depending on the type of case. We're talking low single digits in terms of going to actual trial where you need to testify in person.
Mm-hmm. So what's your take on what percentage do you think would, where you are doing this medical record review, what percent of the cases do you think eventually end up going to trial?
Again, I would say it depends on the specialty. 10 to 15% will go to deposition. And deposition is where you're testifying under oath. And that's usually done in this day and age over Zoom. Sometimes it happens in person, but usually you don't have to travel for that.
Yeah.
And then of that, 5 to 10% of those will end up going to trial. And so you end up with, again, low single digits to kind of mid single digits will eventually go to trial, if at all.
So in almost 85 to 90% of the cases, you would do a record review and not find a breach of the standard of care. How do attorneys take this news when you tell them that they don't really have a case?
Yeah, maybe it's disingenuous, but I call it, how do you tell somebody their kids are ugly? Because it's hard, right? The difficulty in getting into essentially the work that we do is they're paying you to review the records, and now you're telling them there's nothing there, and they just spent money on you to tell them, yeah, that you handed me a bad case, if you will. And so what I would say is, I ask a lot of questions. Are these all the records? What did you see in the case that I didn't see? These are intelligent lawyers. I mean, also keep in mind, that's telling. If this person doesn't do a lot of medical malpractice and they handed you this case, that's informative to them as well, and should be informative to you that this is somebody who maybe is not as skilled in the space. But a lot of times attorneys just don't know. Were there breaches? Yes, just because something bad happened to a patient, that there was a bad outcome, does not mean the standard of care was breached. What I tend to do in those situations after a thorough review, and I say, I'm not seeing any breaches in the standard of care, I usually throw it back to the attorney and ask them, what did you see? This is from the plaintiff side. What did you see that I didn't see? What were you told that I didn't tell? Are there any other records, or where are you concerned? Because I didn't see anything on first pass. Now, from the defense side, when I'm retained by the defense counsel that are defending the doctor's work, I could, you're looking there and saying, yes, they clearly breached the standard of care, and I'm concerned about that, or I'm not sure how you can move forward with this, because the challenges I see is this was pretty egregious for X, Y, and Z reason. And so remember, lawyers don't work in hospitals. They want to know what it's like in the clinic, what it's like in the hospital, what would normally be done. What would a normal doctor in your specialty do in that same or similar circumstance? It's not easy to have those conversations, but I favor the pull the Band-Aid off quickly approach. Say to them, I'm not seeing anything, but you brought this case to me. Did you have that sense, or did you think this was definitely breaches? Because I'm not seeing them. And then you just put it on them to say, we were actually thinking of X, Y, and Z. And then you have a robust back and forth. And sometimes that will result in going back to the records, because sometimes these are thousands of pages and you missed a couple things, or there isn't something there and the attorney understands that. And most attorneys are appreciative, because here's the other thing, as I alluded to before, this is an expensive process for everybody involved. The deeper you go, everybody is spending time and money trying to go through this legal process. And so that's why what we do as expert witnesses is so important. If you tell a lawyer there's something there and there actually isn't, both plaintiff and defense will be going deeper and deeper into the legal process, spending time and valuable resources, attention, and money on something that didn't have merit. And so again, that's, from my standpoint, that's another reason why educating expert witnesses to be able to recognize merit and no merit is important, because we are educating the lawyers, and we could actually influence the legal system by saying, you know what, there was no breach here. Why we should not be pursuing this. And those sort of frivolous cases that leave a bad taste in the mouths of colleagues fall to the wayside.
So would you say that when you give the attorney the so-called bad news that they don't have a case, you're actually saving them probably $50,000 to $75,000 that they would have spent trying to litigate a bad case?
Yeah, I mean, again, these are from the plaintiff side, certainly, without, and from the defense side, I don't tell them how to spend their money. But what I say to them is, if you're going to move forward, you're going to need this expert, this expert, this expert. At least when you're advanced as an expert witness, you feel comfortable with that sort of, because you've seen the anatomy and how these things move forward, and they realize it's a lot of money. So yeah, you're helping them allocate resources effectively, right? You're not jamming up the legal system with a case that's going to end up in lost time and resources and money.
So these medical records can, like you said, it can be anywhere from 1,000 pages to several thousand pages. So how do you do you have a method that you deploy, or some tools where you try and condense the content and distill the content and make it manageable to review these documents? Obviously, I'm sure with experience, you know where to look. But how do you go about managing such high volume of records and reviewing them?
Yeah, what I could teach, and I do teach a whole course and give all sorts of tips on how to do that. Here's just a couple. When you're looking at a case, cases are bounded by something, right? And this may sound grim, but if it includes the death of an individual, likely you're going to have a death certificate, right?
Mm-hmm.
So you have most of the forms, documents that come, at the very least, they can be put into a searchable PDF type of format. And so you can look for, if you know the doctor's name of the care that you're trying to evaluate, you can at least search for that. So that's one tip, one obvious tip. And most of these should be obvious, but you still need to look at all of the records, but it helps you identify the key milestones in those records. And then what I tend to do is I look at that milestone and then work my way out. If you just start at page 1 and you go to page 5,000, don't necessarily find that the most efficient, and I don't recommend that. But as you're alluding to, there's a lot of tools out there that can help analyze records. There are a lot of, in the legal space, there's a group of individuals called legal nurse consultants. Think of them like they're usually nurses who can help condense and summarize and make chronologies. So law firms tend to pay individuals like that or have them on staff already to condense things for you. And certainly that's a sign of a mature expert witness or medical malpractice law firm, is if they come to you and they say, we have a chronology. Now there's legal aspects of if they give you the chronology first, does it bias you? And we can get into the nuance of that. But in terms of just how do you assess the volume of things, certainly making the product searchable is important. And then I look at the bounds of it. Are there death certificates? Are there outside records? And really, it's not wrong to ask the attorney, okay, you're saying something untoward happened. What date did that happen? And so typically what individuals will do is start by that date and then move in both directions, or start a few days before. If the event happened, they say 6 days into his hospitalization, you start at the history and physical and walk through just like you were a regular doctor. It can be challenging. I know folks look at records in many different ways, depending on the type of case. I don't necessarily follow the process I just said. There are just lots of different tools, and basically you decide which tools to bring to which case and which method to use, depending on the events and how they unfolded.
Okay. And you also mentioned that you consult both on the plaintiff and the defense side. And this is something that brings me to the whole concept of the hired gun, where some experts are accused that they only work for the plaintiff's bar or they only do defense work. And it's true for some medical experts as well. I know of a few doctors who would only do defense work and they will not touch any plaintiff's case. So what's your take on, like this preference that some experts have? You clearly don't have a preference like that. But why do you think some experts do have that kind of preference?
I haven't actually asked anybody directly why they may choose one or the other. I've let my practice develop. Whoever calls me and they say, do you want to look at some records? I look at them. The other thing that I mentioned to individuals that I coach and mentor is that you're good when work begets more work. Meaning if you testify and the opposing counsel calls you up, then you know that your ability to convey the healthcare that was provided in an understandable way in front of a jury, or when you were under oath and testifying at a deposition, was better than most, because they want to retain you to work on their cases in the future. And so what I would say is that's when you know you're actually quite good, is that without asking anybody for a case, work comes to you. That you'll see, although I think a lot of individuals not in the space will mention that, like, well, if I did it, I would just do work for one side. But I think those individuals are a minority of the expert witnesses in the space. And when you really speak to the people within the expert witness space, that they are doing a varied amount of work, whether it's for plaintiff or defense. And it's very rare that it's going to be 50-50. You will skew one way or the other. But and there certainly are individuals who say, I will only do defense work. I've just never thought that was the right way to handle my approach to expert witnessing. And you can have a bias in any direction, I suppose. That's, I guess, the easiest way to answer it.
So off the top of your head, can you give us a number as to what's your plaintiff defense ratio? Is it like 50-50 or? like around that?
Generally speaking, and you have to imagine it's a moving target, right? I mean,
Yeah.
for all I know, a case could come in today for
Yeah.
one or the other, and it's not something I necessarily keep track of. Generally speaking, it's about 60 to 70% plaintiff,
Okay.
and then the remainder is defense work.
Mm-hmm. So let's talk about the medicalexpertwitness.com domain that you have and the consulting that you offer through that. So first of all, let me congratulate you about getting the domain. I think it's an excellent domain. And medical expert witness, the keyword is one of the most searched keywords when it within the expert witness. Like when you look at the Google keywords tool and look at the search volume, that's one of the high search volume keywords. So a lot of companies are trying to run ads for that. So great job getting the domain. So what's the story? Like, do you have a backstory there? Why did you think of getting the domain? And if you don't mind us telling, like, did you have to pay a premium for the domain?
I did. I don't know much about the world of domain costs. It was not inexpensive, but it seemed to me to be a good investment. This is a space that I knew I would be in for a fair amount of time, and so I knew that it would be worthwhile to spend the money to invest in that domain name. To your point, it was intuitive, and when I checked to see if it was available, I was also surprised, which is also why I bought it right away. And I can't remember the other question that you had on the heels of that.
No, I mean, so when you got the domain, did you buy the domain? Like, what was the primary reason for buying this domain? Like, let's start from there.
Yeah, so for a number of years, I've mentored individuals on how to get into the medical expert witness space. A few years in, I started helping closest friends. And then from being in the network and on social media and chatting with individuals, I would maybe say, hey, if you want some help, I'm be willing to help you. And due to network effects and just popularity, and I suspect success in those early individuals, a few of my friends and early mentees just said, you should be out there helping more people. And so this was a more concerted effort to just put my name out there into the space and say, you know what, I'm here to help, and I can help you grow your expertise in something that seems intuitive, but is actually completely different than just doing medicine.
Yeah. So do you have a playbook that you apply for your own practice, and then do you teach the same playbook to your mentees who come through the medicalexpertwitness.com program, or like how does the whole thing work?
Yeah, what I would say is obviously there are several iterations over the years as I've learned more, and I think that's the exciting part of this is I will tell you, I'm always a student. I still have mentors, and I pay for mentoring and coaching myself, not necessarily in medical expert witnessing per se, but just in the space of how are you coaching and mentoring other individuals. And what I provide to individuals at medicalexpertwitness.com is how I, looking back, grew my medical expert witness practice and how I skilled up. I provide mentorship that I never had and that I would have wanted, say, 6 or 8 years ago. And so that's how I form things, is I'm teaching you things that I wish were instilled in me 6 or 8 years ago. And it just gives you a warp speed introduction and catches you up based on somebody who's been in the space for a long period of time. So it's nothing that I don't teach anything that I don't use myself or that I haven't used as I was coming up in the space.
So if, let's say, I'm a doctor and I want to get into, like doing work as an expert witness, according to you, what's the minimum years of experience I should have to seriously get considered for doing some record reviews?
Yeah, you need to at least be out of residency and a practicing attending physician. This is for physicians. Nurses, because keep in mind, there are expert witnesses in nursing, physician assistants, nurse practitioners. So just speaking to the physician audience, what I would say is a couple of years of being an attending is important. After a couple of years, I would say then it's really based on your comfort level. I suppose you could do it straight away as an attending. If I'm giving advice to just any young physician, not even in the medical expert witness space, I think those first couple of years out of residency, you should be focusing on becoming the best attending you can, and to solidify that knowledge of practicing independently. I think that is a time that's essential, and you shouldn't distract that by doing other endeavors. such as medical expert witnessing. And so that's why I put the line at give it a couple years of you just being used to being an attending physician and being in charge of a team, and then think about moving on to expert witnessing.
Mm-hmm. And do you have like an internal checklist that doctors can use to decide if it's a good field for them? I mean, it's a great, as some people call it, a side hustle, or it's also a service to society from like, at least that's what my take is. But I'm sure there are like a few skills that you need to have other than the medical skills that doctors possess to be able to succeed, to be able to be a good expert witness. So can you, like talk to us about a few of these skills that as a doctor, I should see if I have those, or I can always develop those, that would make me a good expert witness?
Yeah. The first thing I would say is skills can be learned. The question is, are you willing to learn those skills? Without a doubt, there are individuals who have some of those skills either innately or they've through other endeavors have worked on skills that can be applied to medical expert witnessing, but you understand essentially the standard of care because that's hopefully what you practice every day in your job. And so really it's just the first thing you need to do is just be able to read lots of documents. It's not always thousands of pages. Sometimes it's hundreds. And so that's something that you would have to want to spend some time doing, but you have to be open to those other activities, which might be a deposition, which is essentially being asked questions under oath for several hours straight. I just had a deposition a couple of weeks ago that was 6 hours. And yes, you get to get up and take small breaks, but that is the intensity with which you have to understand a case, that you can ask questions, answer questions that are asked of you for hours on end. That's a piece of advice that I would give to the experts listening as well. It's a piece of scrutiny that when you're evaluating for the standard of care, and it doesn't mean sometimes the standard of care was breached, but you still don't want to be involved with the case because you don't feel that strongly about it, or you're uncomfortable with, you don't practice in an analogous way, but not exactly like the case. And so therefore you don't want to be involved. But the standard that I put on myself at times, or that I recommend other people look at it, the lens they look at it through is, would you feel comfortable answering questions about this case for several hours? And if the answer is no, then you should pass on the case. And again, there's a lot more nuance there, but that's a general rubric where you could say, yes, something untoward happened. Yes, I'm unsure about the care that was provided, but I'm not comfortable proceeding as the expert for this case because of reason X, Y, and Z. And by the way, that answers your prior question before. Lawyers will appreciate that. You're not necessarily telling them maybe that there is no case, for instance, and again, this is evaluating a plaintiff's case, but you're just telling them, I wouldn't be comfortable. And the same goes for defense. I think that's the best way I can not sign up for a case. From the defense side, I can see your point of view for this case, but I'm just imagining being deposed, and it's not something I would feel comfortable for this case. But I'm looking forward to reviewing cases for you in the future. That's really the best answer.
And is there a way for me to only do record reviews behind the scenes and not do testifying work? Is that a career path that's available to doctors?
Absolutely. Typically, by how much you bill, you're going to be paid less to do that. And the reason is, as you can imagine, the time that it takes and the skill that it takes to be a testifying physician and be on the line and be on the stand, if you will, is a different skill. And so that will garnish or you'll end up with a higher rate there. Right. But if you want for a couple $100 an hour, those individuals can review records. I do some of that work. I work with firms, and I have friends that have companies that do that work. It's called pre-litigation work, where you're assessing cases. Larger firms have nurses or nurse practitioners or paralegals screening cases, saying, thumbs up, thumbs down. Is it even worth passing this on to an expert? And if so, which expert? Doing the high level work, there are companies that do that. Experts can do it, but typically you have to understand the medical malpractice arena before you can do that work. So the individuals in that space are usually, not always, retired experts, or not practicing physicians who were experts, who understand the space and can advise lawyers on, yes, this is a case that's worth taking.
Mm-hmm. And let me ask you, like, based on your experience, a couple of things that you think attorneys can do better when they are working with experts. Like, probably bring them early into the case. Like, do you have any examples where an attorney or a firm came to you last minute and they were in a hurry to get a sign off on the certificate of merit?
Yeah, that tends to be red flags there. And they could be, or at least yellow flags, like some sort of warning. It doesn't necessarily mean sometimes experts drop out last minute. Sometimes an expert's sick. Sometimes a colleague is sick and the case got passed to another attorney who all of a sudden found out that there was this deadline that something needed to be done. If there isn't an explanation, not that they necessarily owe you an explanation, but if there isn't a reasonable explanation as to why you're on this tight deadline, that should be a little bit of a warning sign. Maybe they're just a little disorganized. Maybe they're overworked. You have to get a sense. I think it's important to get a sense of, why are you against this deadline? And then the other thing is, I wouldn't compromise. If you don't have enough time to review it, don't take the case. If they're asking for a report or just for your sign off on something and you feel like it wouldn't be a full-throated, concerted effort to review, I wouldn't put your name on it. The advice that I give there is, usually people feel they need to take those cases because they don't have any other cases coming. And that's what I said, like, let's solve that problem for you. I can help you get to a point where you're getting more cases. So those marginal cases, you just need to say no to them. Or those situations where you don't feel comfortable, you can say no to them. And when you're new, you're probably not skilled enough to take those last minute cases because you can't assess a case in as efficient a manner as somebody who's been doing it for a long time.
And the reason I asked is because I remember a specific case where a law firm reached out and they wanted a certificate of merit on a nursing home malpractice case from a nurse who had a certain kind of experience, and they wanted the certificate to be signed the next day after reviewing 100 pages of records. And we were able to find somebody who was available, but that's a different story. It's always a tricky situation. Another tricky situation that attorneys find themselves in, and I really want to get your opinion on that, is that they are unable to find a doctor who is available to do expert witness work, has the right credentials and the right experience. And they are unable to do so because these doctors would have no publicly available information about the fact that they do expert witness work, which has also created this whole expert referral industry. So why do you think doctors make it so difficult to make it known that they do expert witness work, number one? And secondly, the contact informations are always a little difficult to find. Again, not the case with you, but with a lot of doctors. So do you have an opinion about that? What's your take on that?
I mean, physicians tend to be quite busy. So okay. I think, and they see this as not their main endeavor, perhaps. And they are, again, maybe they're new and they don't understand the importance of being findable. And, when you speak to experts, some experts are fine advertising, others don't. And they know that they're going to be scrutinized. I think that that's the challenge that a lot of experts have, is they are uncomfortable wading into that conversation. Why do you advertise? And the answer is, well, you wouldn't have found me if I didn't advertise. But I think that's a lot of it. And some of it is a lot of experts, if their goal is to have a couple cases a year, once they get going, the referrals can sustain that. So a lot of people are unfindable because their small network that they've made gives them the caseload that they're looking for. And so I agree with you. It ends up being a disjointed network. As you can imagine, there's always new people coming in to be expert witnesses. We both would probably agree that that number has increased substantially in recent years, I would say since COVID. And there are retiring experts or experts who, in most jurisdictions, generally speaking, at the time that the alleged incident occurred, you need to be practicing. And each jurisdiction, there's different timelines around that. But if you stop practicing medicine, you essentially start the clock on how much longer you can be an expert witness. And so there's always people exiting the expert witness field. And so I think you take into all those factors and you end up with a situation where it can be challenging to find an individual, especially on a tight timeline, find the right individual for your case.
So if I'm a doctor and I want to put my name out, like let people and let attorneys know that I do expert witness work, what are a few things that I should be doing to get my name out? And is that something that you help experts with through your medical expert witness mentorship program?
Yeah, I have an agency component to medicalexpertwitness.com. And so we help individuals build their own expert witness. It's not agency or their own expert witness practice, if you will, and curate the lawyers and the cases coming in over the subsequent years. My idea there was not necessarily to be a broker, to broker the case connections, but to help the individuals that come to me build their own practice so that in a few years' time, once they have that base of work that they've done, the referrals will sustain them and they no longer need my services if they so choose to step aside. And I think that the first thing I would do is make sure you want to grow. I think a lot of people come into that are new say, I want to grow. I'm ready for lots of cases. And what I would say is there's typically about 5 things that I like to see when somebody's really ready to grow. They've done some of the work. They like it because remember, not everybody who does this is going to enjoy it. They've been told that they're good at it without soliciting that, like a lawyer tells them they're good at it, right? They've spent some money in the space and want to grow, but aren't exactly sure how to deploy those resources. And typically, those individuals may have a bit of extra time. Again, the more senior the physician, the fit of being an expert witness works. And a lot of those folks, I'm not judging anybody with kids or without kids, but a lot of the folks tend to be approaching empty nest, what we call empty nesters. So their household is empty. I certainly am not an empty nester, but I'm plus years into my career in medicine. And so individuals in that space tend to have the bandwidth, if you will, to go into this space.
So can you share with us a couple of specific ways in which you help these people set up their practice and grow their practice?
Yeah, I think it's certainly depends on what the individual's goal is. So where we start is where that individual is. Why do they want to do expert witnessing? What is their goal and what is their bandwidth for taking on cases? You have to keep in mind as you're taking on these cases, if you're practicing 100% time and you're working 80 hours a week as a physician, this is going to be difficult to do because a deposition is taking a morning off or an afternoon off. And while depositions may not occur immediately and there's flexible in scheduling them, you have to think towards the future. So that's typically what I'm doing on screening somebody in terms of how to grow their expert witness practice, because a lot of people say they want something but really aren't certain about what they want. For those who want to grow, it really comes down to putting an eye to the past. I want to know what kind of cases they've done, who they've worked for, where they think they've thrived, what's been challenging for them, so that can help identify which skills they need to work on, but also which areas we could double down on that they've done quite well.
And based on
then it's how have they?
No, yeah, sorry. Go ahead.
Then it's engaged the market so far. There are individuals who work for hospitals and hospital systems or practices that don't want them advertising. And so that becomes a little bit more challenging, but that's something that my agency specializes in, is how do we get you cases when you are prohibited from putting your name out there in a certain way.
So what are some of the mistakes that you've seen experts make when they are like either trying to get their name out, or even when maybe experts on the opposing side who are testifying, or or the reports that you have read from opposing experts?
That's a good question. What I would say is mixing their regular business and medical expert witnessing together. I see people that have websites where they're putting both of them together, and I think they should be seen as separate endeavors. I think that the other piece that individuals can be on social media is there's now this cacophony of hey, do you have a case? And they're soliciting too much. They're asking for too much business and not really providing much value. It's far easier to engage with a company or a service that will help you with the networking and the connections than just throwing it out there on social media. I think I'm not faulting the physicians for doing that. It's just not, they may not be aware of the most efficient ways to do things. I think there's tasteful ways of doing it and other ways that seem a little distasteful. And the best thing you can do is interact with individuals who have been doing this for a long time to get their advice.
Since our beginning in this industry has been, on the legal research side, where we've looked at the Daubert standard and, like how experts have done in court and how they have, fared against these challenges. So how important do you think it is for experts to be aware of the legal standard around expert witness testimony? Like there's the whole standard of care in medicine. But what about the legal standard that would admit your testimony in court or get you excluded? So how important is understanding all these things, and how did you develop your understanding around the law related to expert witness work?
I would say slowly at first. Again, when I started off, I didn't really think, I wasn't thinking a decade into the future. I wasn't thinking I would be in this position. I was helping a colleague with one case, and then he provided me another case. What you're pointing out, the rules of the game, so to speak, not only are they different by and differ by every jurisdiction, and by jurisdiction I mean one state to another, but the Daubert standard, and for those experts that might be new, you just because you're a physician does not mean you are entitled to give your opinion as an expert witness. Your opinions that you give can be stricken if you are found to be testifying in things that you're not deemed to be an expert in. And while that may seem intuitive, one of the cautionary tales that I give to experts, and I'll certainly say it right now, is it is tempting when a lawyer wants to give you a case and therefore give you an opportunity to bill, let's say, $500 an hour. You're going to be in positions where you need to say no because you are not a good fit for that case. Not only that, but you could be tempted to take a case from a lawyer who is not that skilled in medical malpractice. And that's why when they are interviewing you as an expert witness, you need to also be making sure they are a good fit for you. And this is your point. When there is a Daubert challenge, when there is a challenge as to are you a fit to be an expert witness for this case, if that lawyer who retains you is not skilled and your opinions are stricken, doesn't mean you can never testify again, but it really cramps down and brings in the guardrails for what you can testify about in the future. So be very careful. I've seen far too many experts cavalier in just trying to, what I say, collect retainers. They're just trying to get business. I'll just review the case and tell them there's nothing there. I've seen people where it's a slippery slope. They take the retainer and then they're cajoled into saying, okay, I'll go a little further. And then they're in deposition and, well, it's never going to get to trial. And then all of a sudden their opinions are stricken either because the attorney, and you can have, by the way, you can have a skilled attorney who just loses a Daubert challenge as well. And so it is a slippery slope, and experts have to be extra careful when they're starting out, that they have mentors who know how to navigate the system, but also that they're just not being so cavalier in saying, well, I'm just being paid to review a case. What's the big deal? The answer is it's a huge responsibility. And I see this, again, one of the reasons why I've started medicalexpertwitness.com is it's essential to have the individuals in this space to guide the new coming expert witnesses to avoid these sorts of mistakes.
And so are there any telltales that a lawyer is not a good fit or the lawyer is not experienced enough? Like lawyers would look into the testimonial history of an expert to see how many cases they have worked on, how many court documents reference an expert witness. Is that something that an expert should do as well? Look into the history of a lawyer, like how many malpractice cases they have done, how many years do they have as a lawyer? Like when did they pass the bar? Like, do you suggest experts should look into the credentials and the history of a lawyer before agreeing to do expert witness work, or any other telltales?
Probably, yeah, probably not. I would say that the vast majority of expert witnesses are going to start slow and are probably going to do a small handful of cases per year. And the vast majority of attorneys that are coming to them are great actors in the space. They have good intentions, and it's probably not worth the expert's time to do a Google search or try to glean some sort of information. I mean, you could avoid some red flags. You know, if they have no website, they're doing this as a favor to a friend. I avoid those. Individuals who are representing themselves, I tend to avoid those cases. I could be wrong, but I think those to me are like obvious red flags and have a higher potential for conflicts and less success for the individual. And you're trying to be helpful, but to be a helpful expert witness, you also need to be in the space for longer so you have the experience, so you can provide that experience. And so if you come in and you take a few cases that are hamstring you because you're involved in a Daubert challenge, that's unfortunate. And so that's really what I try to advise individuals to do, is those first few cases that you do are very important. Those first couple of years, how you start is very important.
Yeah, I mean, a Daubert challenge has pretty much become like a table stakes these days. Like if you're an expert and you've been retained, more likely than not, there will be a Daubert challenge. But how the court rules on that Daubert challenge is like a lot of it depends on your report and your testimony, what you have agreed for. A lot of times experts don't even realize that they get, Dauberted, as the verb goes. And do you suggest, what's your take on following up with the attorney on developments in a case? Like you've submitted your report, a Daubert challenge gets filed. The attorney may or may not tell you. How do you factor that in, and do you have any suggestions on tackling that aspect of the case?
Generally speaking, listen, when you start out and you have a couple cases, it's a lot easier to follow up. When you've been at it for 10 years, I mean, there might be some cases from 6 years ago that haven't been settled yet. I've taken the tact, and this is just the teaching that I've gotten, is that, yes, it's important to reach out, but I don't do it as frequently as some people. When you start out, I don't think it's wrong. As you know, the tail on these cases can be anywhere from either they don't file the case and you know that, or the case could be 18, 24, 36 months or more before resolution. Following up quarterly is probably overly burdensome for everyone involved. I think every 6 months to once a year, following up with retained attorneys is not a bad idea. I typically, for instance, if a case goes to trial, maybe a couple months, if I haven't heard from the attorney, usually a couple months later, once it goes to trial, there's a public database. I'll look in the database to see maybe what the result was of the case, what the decision was of the jury. I don't think you need to be overtly concerned about the results. Again, you're there to testify as to the standard of care, or did the care cause harm or not cause harm. I think that's where your focus should be. The outcome of the case, while it may be interesting, as an expert, you won't have and you shouldn't have a dog in the fight. You're retained by one side to comment on the care of the providers on the other side of the case. And that's how I see it. So I know it's tempting to kind of follow these things. It might be interesting. I don't know if it's essential to an expert witness's practice.
Mm-hmm. So should an expert have like a clause in the retainer agreement that which requires the attorney to notify them if their testimony has been challenged?
I haven't looked at my agreement recently to see if that's in there, and certainly in depositions you're asked that. And so I think it's perhaps nice to be aware of it. I don't think it's essential. Typically you would know if you had, and again, having a challenge is one thing, right? They'll debate it. Whether or not it was successful is something else. Yeah. And to your point, I think it's part and parcel. It's a tactic that's used these days, because if you throw enough things against the wall, sometimes something will stick. And even if they didn't think it would stick, maybe it would. And so I think that Daubert challenges happen, if you look over the years, probably a lot more frequently now. It's for the lawyer, it's probably more important, but as a new expert witness, it's probably a distraction, and you'd be better off spending that time building your skills and reviewing records.
Thanks a lot, Dr. Romano. This has been, I can keep asking you questions for a couple of more hours, but I wouldn't, take all your day today. So this has been really helpful. I've learned a lot. I'm sure the experts, attorneys, whoever listens to this episode, they'll have a lot of takeaways from this. I usually ask my guest that if people want to reach out to them, where should they go? In your case, it's medicalexpertwitness.com, a domain that will be difficult to forget. But other than that, what's the best way to, contact you?
Yeah, I love chatting. As you can tell, I love chatting about medical expert witnessing. If you go to medicalexpertwitness.com, you can book time to chat with me, whether you're a new or an established expert witness, or you're a lawyer. I help out individuals, expert witnesses, with coaching and through my agency, but I also speak at conferences, and I also do pre-litigation work for attorneys. So my goal is to help everyone in this space raise the bar in terms of their skill level. So feel free to reach out. I'd love to chat with you.
All right. Thanks a lot, Dr. Romano, and I hope to speak to you soon again.
Fantastic. Thanks for having me.
If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.